Hello everybody. So, welcome back to Psych and Law. Oops. We're going to do lecture 14 this time, and this is Rights of the Accused, rights extended to juveniles. So we'll take care of rights of the accused first, and going to talk about some important court cases and how those then have modified the rights that we have as part of our due process phenomenon. And then we'll talk about juveniles for a little bit after that. So, this is in large part, right, are we talking here the protection of the individual, or are we talking about the protection of society? So it's the rights versus the control, in large part for the first part of this lecture. So I want to talk about rights of the accused, and we're going to look at Mapp versus Ohio as part of this Gideon versus Wainwright, Miranda versus Arizona, and yeah, you probably should know these because I'll refer to them in the exams by these names. Jackson versus Deno. We'll talk about the Fourth Amendment, and we'll look at some research regarding the Fourth Amendment and people's perception of the Fourth Amendment. And then we'll look at juveniles, right, and victims' rights. So, again, we have to reference these in terms of the Supreme Court because the Supreme Court is labeled in terms of the Chief Justice, right? And so we're going to talk about the Warren Court leads off. We're back late 50s, early 60s, and what do we see? In Mapp versus Ohio, this created what was called the exclusionary rule. And Dorley Mapp was under suspicion of harboring a fugitive, perhaps. The police wanted to come in and they wanted to look around. They wanted to look for bomb-making devices, that this was kind of a terrorist issue. And what happened is they come to the door and they bang on the door and they say, Dorley Mapp, we want to come in and search your premises. She says, no, you know, kind of screw you. And, you know, they produce a warrant, but maybe they didn't have a warrant. We don't really know if they had a warrant or not. They showed her a piece of paper. They come in. They don't find any bomb-making materials or who they're looking for, but they do find pornography. Believe it or not, back in the day, pornography was illegal, so she's arrested on pornography. But the idea is the exclusionary rule stated that, look, if you don't have a warrant, or if you find something that isn't named in the warrant, then it can't be used as evidence in court, and hence if it can't be used as evidence in court, then there's probably no reason to go to court. So the exclusionary rule was basically saying if you don't have a warrant, or if it's not specified in the warrant and you find it, then you can't use it in court. So don't bother. And really the idea is that it's based on the perception of the need to deter the police from conducting illegal searches, to go on fishing expeditions. That is, you have to have probable cause, you have to bring that cause in front of an independent party, that is the judge. The judge will sign off on the warrant, and then you can go back and look for what you wanted in a legal fashion. If you don't do that, and you just try and be tricky and go in and find whatever you want to find, whether it's there or not, the whole idea was don't bother because you're not going to get to use it in court. Your case is just going to get thrown out. So it really was based on the need to deter police from operating fast and loose and performing illegal searches, because it won't do them any good anyway. So this is really bound to the Fourth Amendment guaranteeing your right to be secure in your person, your houses, your papers, and your effects. Now, the Fourth Amendment cases abound, Fourth Amendment laws, confusing as all hell, and it's a shifting landscape of court cases that offer different decisions, modifications in decisions, so you never, this is a wide open territory and it's ever changing. Do the police have the right to search your car? Well, you know, it depends, right? And it gets into this whole kind of conditional setting. Now, one thing I do want to say here, and one big interpretation, right, and this Fourth Amendment was weakened hugely by the Patriot Act as a result of 9/11. But to be secure, and this is as is stated in the Fourth Amendment, your person, your houses, your papers, and your effects. So if I have a bunch of papers somewhere here in my house, you can't take them without a search warrant, etc. But guess what? It's very easy to search my electronic devices. And basically anything that you transmit electronically, figure that it's fair game for anyone who wants to find it without a warrant necessarily. So, and you say, but we don't use paper anymore. We use electronics. And you know, the courts come back and say, yeah, well, tough shit. right? So that's kind of the way it goes down. We find that a lot of due process over the last 20, 30 years is being kind of bowled over in the name of safety and fighting terrorism. So for better or for worse, you create your value judgment on that, right, Penelope? That's one way or another. Okay. So let's continue. Fay versus Noya. Unlike Caminito and Benoyo, Caminito didn't want to appeal his conviction. It was a murder charge. The deal was that he's been convicted. He wants to get out, but if he tries an appeal and his appeal fails, then the murder charge sticks. His issue was that he confessed, but he wants to maintain that his confession was coerced, and wants to try to get the confession thrown out, right? And that's what you would do in the appeal court. His interrogation was 27 hours long. He was denied access to family and an attorney, so he's arguing that his confession was coerced. He had no money. He didn't want to risk the possible death penalty if he was retried at the state level. So, anytime that he believes there's a conviction in violation of the law, the Constitution, the Bill of Rights, then the federal court can be asked to issue a writ of habeas corpus, which literally means show me the body, right? And show me the body translates to a release from unlawful imprisonment. That is, you were imprisoned unjustly. So it's a quick way to get around this, right? And Coleman versus Thompson in 1991 has largely reversed this decision. And now we get finer and finer grained conditions that pertain to the application of these court cases. But big picture is that in 1963, we're looking at increased due process. So in this case, the writ of habeas corpus was able to get him out of prison, right? Based on an illegal confession. Oh, by the way, which president, here's a trivia question, right? Which president overturned or disallowed habeas corpus? During the Civil War, it was Abraham Lincoln, just in case you wanted to know. All right, so more due process. What do we know? Gideon versus Wainwright. This is about getting you an attorney, right? So what do we have here? That the government hires lawyers to prosecute those accused that can afford to hire attorneys, right? To defend can be taken as evidence that lawyers are necessary to a fair defense. And by this handwritten plea submitted to the courts, we are now guaranteed a right to an attorney. And this is a big one. Now, it originally only applied to felonies, but once it applied to felonies, that you are allowed an attorney, right? You'll be provided an attorney for your defense. Once it's done for felonies, then it's, you know, a short trickle of cases before it's extended to misdemeanors. And that was in Arkansas versus Hamlin, right? Let's talk a bit more that's shifting towards due process, and again, in the early 60s, right? So in this case, we're going to talk about Miranda versus Arizona, and this is probably one of the most famous cases because it was the basis of your Miranda rights. What happened is Miranda was suspected of committing a rape, right? And he was ID'd in a lineup, etc. And no, I'm sorry. Let me get that backwards. He wasn't specifically identified in a lineup. He confessed to the rape and kidnapping, but the problem is, was this confession coerced? Was it under duress, right? The court ruled that suspects must be warned of the following rights as a result in this case. That you have the right to remain silent, what you say may be used against you, and you can have a lawyer present, and if you can't afford a lawyer, one will be supplied for you. And the following procedures. If you change your mind after waiving the right to attorney, no, I'll talk to you, but then you see it's not going well, and you say, no, I don't want to answer any more questions, I need an attorney now, they got to stop asking you questions and get you one. So in this way, the confession was thrown out on the basis of he wasn't properly warned about what would happen as a result of the confession. So, interesting about Miranda versus Arizona. So now he's freed from his conviction, right? Miranda rights become the letter of the law. Later, in a gambling incident, Miranda was stabbed and killed in this gambling incident, and of course his killer was Mirandized. So that's strange, if you will, right? So prosecution bears the burden of demonstrating the waiver was freely given and understood. So the prosecution will have to state, yes, the person was Mirandized, yes, they assented to answer the questions, and yes, they were competent to do so. And yet more. Now, this one is an interesting one. R.E. Gault extended the rights to juveniles. Right? So prior to this, juvenile court was much different than adult court. Adult court, you're innocent until proven guilty, and it's adversarial. Juvenile court was much more, hey, you did this and we need to repair the damage. So it was much more inquisitorial than adversarial when you were describing juvenile court. Okay? Now, Jackson versus Deno, 1964, pre-trial hearing to assess the voluntariness of confession was now. And this was a big defense because remember, people can't discount confession evidence successfully, the research shows. So why not get it tossed out at pre-trial, as we discussed back then? Concerned that the jury may not be able to disregard the confession that's later allowed. So that really typifies kind of the Warren Court and what people would consider the great swing of the pendulum towards due process. But at some point, as we get into the late 60s, but especially the 70s, and you know, Nixon ran in large part, as a law and order president. And he said the courts had gone soft, the laws were favoring the criminals, victims were getting screwed over, society was suffering. So there's this general taste for law and order that's going to start pushing the pendulum back towards eliminating due process and increasing control. The concern was really that the accused had more rights than the victims, and there may be some truth to that, and it's a matter of opinion. Recent presidents have been law and order presidents, and that reflects appointments to the Supreme Court as get tough on crime. And notice, this is not a party issue. Nixon was tough on crime, Reagan was tough on crime, but remember, Clinton came out in the 90s being very tough on crime and created the term super predators that went on to haunt Hillary Clinton during the election because it was really kind of a racist tinged term, that it was being applied to black gang members as kind of warriors on our society. So this get tough on crime is not owned by necessarily a single party. We don't need to go there necessarily. What I want to do, though, is have a little fun with it, and that is the idea, I know, have fun with tough on crime, but the movie industry. And the question is, kind of the sub-issue here is, do movies reflect or do they kind of direct what we become or who we become? And it's probably a combination of both. That we see things happening that seem topical, so script writers then latch onto that, and then it becomes bigger than life, and it influences people who then start following that direction, and then more movies are written about it, and it becomes cyclical. But I want to talk about this Deathwish franchise, and there are 4 Deathwish movies. If you want to watch the first 2, I think they're really probably pretty good movies. 3 and 4 getting pretty far afield. They feature the actor Charles Bronson, who is one of the original tough guys in the movies, and he is truly tough. Let's talk about then Charles Bronson in the movie, and what we see is that a gang of raving hoods, or roving hoods, break into his house and they kill his wife and attack his daughter. His daughter is left essentially in a vegetative state, and she's going to need to be institutionalized and move her way through therapy back out of that. Now, Bronson's character, right, is an architect, and he's devastated by these losses in his life, and he's just kind of going through the motions of life. He's kind of numb. And at some point, one of his friends kind of gives him a gun and says, look, this is a dangerous place. New York City is not safe to be out anymore. You need to protect yourself, and you can see, because you needed to protect your family. And he grudgingly accepts the gun, but eventually one night he's out walking because he's just trying to clear his head from all the turmoil he's been in, and he's attacked, he's mugged, right? And produces the gun and stops the mugging. And this gives him this light bulb goes off on Charles Bronson's head, and what he does is he becomes a vigilante. So now he goes out purposefully every night to put himself in harm's way, to get robbed, to get mugged, whatever, and then take his vengeance out, his law and order vengeance on the people who are perpetrating the crimes against him. So the movie, the subplot then is the press, the New York press, right, is picking up on this vigilante who's out there, and that's what the police have called him, the vigilante, who's out there. And in the movie it's written that the crime rate just drops off dramatically because of the presence of the vigilante, i.e. criminals are afraid to do their crime thing because the vigilante might shoot their ass. Eventually he's caught, but rather than risk trying him in court, an unpopular trial of the vigilante, right, they suggest he move to Los Angeles and they kind of fix him up. That's where Deathwish 2 takes place, is in Los Angeles, with essentially the same storyline. Now what we have is Citizen, who is no longer protected by the government, or feels he's no longer protected to the government, takes the law in his own hands and gets tough on crime. The idea is that we live out our fantasy of wanting to be tough on crime because we're feeling greater and greater victimization, and more so that the courts don't care, right? So that's kind of where we're at there. Hold on a second, if you will. Let's see what these cats are doing. What are you guys doing over here? Huh? Are you getting bad? Sorry about that. They're always up to something, or not. Sometimes they sleep, so that's cool. Now, other movies that kind of typify the same attitude was the Clint Eastwood and the Dirty Harry series of movies, right? And there's what, 5, 6, 7 Dirty Harry movies. Here, it's a little different. It's not a civilian, it's an officer. But now this officer who's trying to, tough officer, Harry Callahan, right, played by Clint Eastwood, is going to go out and he's going to catch these bad guys, and he's better at it than anyone else. But every time he turns around, it's like, oh my God, now I got to read them rights. Oh my God, now I got to get a search warrant. Oh my God. You know, and he's just an old school cop reacting to all these new court decisions that can more and more constrain his cop behavior, right? So Dirty Harry then is idealized as a cop who goes against all these crazy rules that society is creating that protect the criminal. So we see all the taglines from Dirty Harry, and he carries a .44 Magnum, you know, a non-issue firearm, and, you know, what do you say, punk? Do you feel lucky? As he's pointing, you know, his pistol at a suspect. At one case, he wants the guy to confess who's kidnapped a girl and she's going to die if they don't find her in the next 8 hours. So he shoots the guy literally in the thigh to get a confession out of him of where the girl is. I mean, it's just kind of over the top, but it really represents, I think, where people's thinking was at the time. And these are very, very popular movies. Dirty Harry was such a popular movie, and Dirty Harry carried, you know, immortalized that Smith & Wesson Model 29 .44 Magnum. You couldn't buy one of those revolvers. You had to go like on a 2-year waiting list because they became so popular because of the movie, right? So, but then what happens in real life? And we see people carrying guns in real life to defend themselves against these threats that are portrayed in the media. And Bernard Goetz is one of these guys. So he's riding a subway, and in this New York subway, at some point he feels threatened. He produces his gun and he starts shooting the guys that were threatening him, some black youths. And now he got a big issue. Was he justified in doing this? And let's look at the Bernard Goetz case then. The court stated that attempted homicide was not justified because Goetz, the individual, had believed his life and was in danger. So the court invoked the elusive reasonable person standard, stating that a person's belief he or she in danger must be reasonable under the circumstances. So the idea was, hey, I'm on the subway, these guys are like threatening me, and I felt though I was in imminent danger of physical injury or death, and that's why I produced my gun and started shooting. That's the defense of the use of deadly force, right? In other words, the standard for what is reasonable is not based on individual belief, as the lower New York court believed. It's based on what most people would do in a given situation. And this becomes an interesting issue of psychological tension, because I'm arguing that I'm operating as a reasonable person. But who determines what a reasonable person would do in this situation? And I think ultimately where people wanted that to go was back to the jury. What does the jury consider reasonable based on the instructions that are given by the judge, right? Because otherwise, you know, the appellate court said it just begins, people would begin to set their own standards for justified killings and other violations of the law. It's like, that guy over there, you know, in the alley 2 blocks away, looks like he might come, and it'd be reasonable for me to take him out now before he comes here and hurts my family. Well, most people in the community are not going to think that's reasonable, and that's really what should determine what's reasonable, not the actual individual. So these courts often refer to, but don't really define a reasonable person. The jury usually decides on what's reasonable, and that's so. Gought's jury found his actions to be reasonable under the circumstances. They acquitted him of the shooting of these young men. However, he's still convicted of illegal gun possession, and he was sentenced to a brief time in jail. Now, in 1996, he was sued by one of the youths who paid $43 million to Darrell Cabey. The crime was down in the city. The subway system had been improved. So people found his actions to be less reasonable based on the circumstances as viewed from a later point in time. And that's a big civil suit. So while he avoided criminal prosecution, he lost a civil suit big time. Okay, let's cut it there, and we'll come back for more Penelope petting and part 2.